Welcome to A Way Forward, the right to recover.
Welcome to A Way Forward, the right to recover with attorney Richard Casey III, partner at Robinson and Casey PLLC. Richard focuses on helping families navigate legal options when addiction or serious mental illness creates an urgent safety concern. His work includes Marchment Act cases, mental health guardianships, and advocacy around treatment access and oversight. I'm Lisa Mosbey, your host, and today we're walking through what actually happens during the assessment and stabilization phase of a Marchment Act case and what families should expect during that early stage. Welcome, Richard. Thank you so much for joining me again today.
Thank you, Lisa. It's great to see you.
Yeah, Richard, once a Marchment Act petition is granted, families often hear about something called the assessment and stabilization phase. What is that phase intended to accomplish?
Yeah, so when you're filing a petition for treatment involuntarily through the court system, one of the things the court really wants to ensure is due process, which is to make sure that the individual has procedural rights adhered to in the legal process and that there's substantial evidence to back that up. So, the first step that a lot of families must proceed through is obtaining an assessment. Um, Now, what the Florida legislature has uh, written in the law is that the families have this opportunity to petition the court and ask for that assessment to be done at a particular facility, to have their loved one picked up by law enforcement and brought into that facility, and then to have the facility not just um, assess them for whether or not they meet the Marchment Act criteria and what type of treatment they should be getting, but also to make sure that they're stabilized and that they're being treated for both their medical issues as well as their substance use while in that initial phase. But it does only last for a 72-hour period unless the facility asks for extra time from the court or there's justification around the treatment of medical conditions requiring them to be maintained in the facility until the hearing date. And so that hearing date is in the first 10 days. So it's going to be at least for 72 hours, up to 10 days, technically, that you would have this assessment and stabilization window where someone who may not have already had a court date um, can be picked up by law enforcement and brought in to be assessed and stabilized. Sometimes this does happen after the initial court date, depending upon the court's ruling and determination. But the goal is to get accurate clinical recommendations that we can all be confident um, in the need and necessity of this involuntary treatment once an order is entered.
Just to clarify, can you tell me where does that assessment typically take place and who is responsible for conducting it?
Yeah, so the assessment can take place at a variety of different locations, depending upon which county the petition is being filed in. So the one thing about our firm at Robinson and Casey is that we'll work in any county throughout the state. And what we've really done is try to identify what the procedural processes are, and they vary greatly. So there's no one particular um, you know, standard procedure. There is a law that must be followed, but each county and then each judge could technically have its own manner of implementing that law. And so we're probably the foremost expert on the Florida counties. Now, there might be people that have filed more in a particular remote county, but very unlikely that there's anyone that's filed in more locations than us throughout the state as recently as we have. And what we know is that some of these assessment locations are going to be at a county designated facility. And that might be that there's a particular hospital that will perform the assessments and that court system is only going to grant an order for assessment at that designated hospital. However, the law doesn't require that. The law allows the court to enter orders for the individual to be assessed at private licensed service providers. And so the WHO is a licensed service provider. And at that licensed service provider, a qualified professional, which is also defined in the law, must be able to perform that assessment and give that assessment back to the court. Qualified professionals include physicians, physician's assistants, certain types of licensed nurses, licensed clinical social workers, licensed marriage and family therapists, um, licensed mental health counselors, but also individuals who have a master's degree and are certified as addiction professionals by the state of Florida have the ability to perform these assessments at a licensed service provider. Um, so in some counties, the court is going to be open to the family identifying and selecting their preferred assessment location so that they've made arrangements there. They know that there's bed availability. They know that those things are going to be done competently. And they've worked with a lot of these facilities in the past, so they're aware of their veracity, right? Their truthfulness, their capability, their credibility when they come in. So they're not concerned. And not every person is going to meet criteria or have the same recommendation for level of care. Um, so the court's aware of that. In other counties, the court is unwilling to consider any private facility or recommendation submitted, and they will only allow assessments to be completed by a county designated location. And it could be anywhere that court decides it's the place that they're the only one that they want to get assessments from. Um, and we have to kind of know when you're going into filing a petition, which type of court you're in. There's no right or wrong reason. And then it becomes how will the facility that will be selected, either by you personally or by the court, how will they perform an assessment? What's their responsiveness? How good are they at that? Do they communicate? Do they file the documentation? Do they not file the documentation? Do you have to follow up with them? Or subpoenas required? There's a lot of nuances the families need to kind of consider going into.
And that is going to be one of my questions. But first, I wanted to know specifically, what are professionals looking for during this phase when deciding whether further treatment is necessary?
Yeah, I mean, those are great questions. And sometimes I'll get carried away. So I apologize. When you get to know me, you know that I just talk, I use my hands, I get comfortable, and I'll just spew. But hopefully in a good way. So, um, what are professionals looking for to determine whether or not treatment is necessary? There's specific criteria that the Marchment Act requires to be met for a Marchment Act order to be entered, right? For someone to be ordered to treatment under the Marchment Act, certain criteria must be met. So the clinician is definitely looking for whether or not they meet those criteria. But usually the clinicians are even more so trained to be looking at things from their lens, their perspective as clinicians, right? Not necessarily as a witness in a legal proceeding. And so what you're going to see is the clinicians are looking, does this person have a substance use disorder? Did they come in and test positive for drugs or alcohol? If they didn't, are they acknowledging their use of substances? If they did, are they acknowledging the use of substances? How truthful are they? What information are they receiving from collateral sources and from the patient and from um, the medical analyses they can do? Um, what is their presentation? How do they behave? What is overall the patient um, biopsychosocial assessment, biology, sociology, and psychology components, indicating about the patient's need for treatment, and can they use a gold standard assessment tool that's accepted across the nation and sometimes even the world, but certainly in the state of Florida, to place them in a particular level of care. What type of services do they in fact need? So ASAM criteria is the American Society of Addiction Medicine, ASAM, provides a lens to which the clinician can use to determine what level of care is appropriate. Do they need detox? Do they need residential? Do they need partial hospitalization? Do they need IOP? Or are they appropriate to be in regular traditional outpatient? And where do they come in across that spectrum? Where's the right place to place them? And so they're going to do that type of analysis. And when they are doing that, they're also going to be able to draw upon right? How that patient's presentation goes into the criteria of the Marchment Act. So one of the criteria is, do they have a substance use disorder? The law says it a little bit differently. It says, are they substance abuse impaired, quote, end quote, which means, are they using, abusing, or dependent on alcohol or prescription or illicit substances in such a manner as to um, create socially dysfunctional behavior, or do they have a substance use disorder? It literally says that, right? So they're looking at this and they're saying, do they have that? Okay. Have they lost the power of self-control regarding their substance abuse? Is a high-level criteria, usually used more in the assessment phase, and is not required to be proved at the treatment services hearing. It actually says exactly what needs to be proved at the treatment services hearing, and that is not included. It says, does the patient have a history of lack of compliance with treatment for substance abuse? And so we are looking at their most recent history, but also their past history. And have they been able to follow through? Have they been um, compliant or lacking compliance with whatever the treatment recommendations were? Were they told to go to IOP and didn't? They just did their 30 days residential and went home and then relapsed. Were they told that they should go to AA meetings and get a sponsor, but they never attended it? They didn't care. Were they told that they are not allowed to use drugs in treatment and they relapsed inside the treatment milieu, right? Were they told that the most important thing that they could do is remain abstinent, but time and time and time again, they continue to go back to use over multiple treatment episodes? They might be superficially compliant inside of treatment, but ultimately never actually be compliant with what the treatment recommendations are for their well-being. And so so the clinicians are potentially thinking through, how is this patient presenting? What's their prior history? What other treatments have they been to? And then they're going to look at, are they, if they're not in treatment, are they likely to neglect or refuse to care for themselves? Is that a danger to them? Will they hurt themselves? And do they have the ability to really rationally, or is their judgment impaired so much so that they cannot rationally determine what type of treatment's actually necessary for them to recover? Not what they're willing to do. What they're willing to do is to continue down the path to self-destruction often. But the question is, do they have the ability to truly understand their need for treatment? Or has their substances created a denial or ignorance component in their mind about how serious their condition is and how much treatment they actually do need in order to live a successful and happy life?
And Richard, how long does that assessment and stabilization phase usually last under Florida law? And a part of that would be what happens if the person is resistant or uncooperative during that early phase?
Yeah, so the law gives the facility 72 hours in order to complete the assessment itself. And it gives them the ability to extend that to um, the Monday after a weekend or after a holiday. It gives them the ability to ask the court for more time if necessary. And it gives them the authority to keep the patients if they need additional medical attention. And that's the component of stabilization. And that runs itself up to the potential hearing date. So it's initially that 72 hours. However, the facility is really the person determining, right? The facility and the qualified professional are really the um, the experts and people determining how long to keep them along that continuum. So if they come in and they sit with somebody in one county at a particular hospital, they might take an hour to 3 hours to do what they determine is an assessment, and on their way they go, right? And in another county, you might work with a private treatment provider who's going to bring them in, who's going to settle them in, who's going to have them meet with a nursing staff, who's going to meet with a physician, who's going to have them meet with a psychiatrist, who's going to have them meet with a licensed clinical social worker. They're going to do a battery. They're going to do a full assessment, the appropriate clinical needs to determine what's right for them. So often, early in the case, when someone calls our office, we can't get to all of this, but we're basically saying, hey, you're located in a county that does it this way, but you'd be much better off if you were located in a county if you did it this way. We can do either one. We're happy to help. This way may actually cost more and be more difficult. This way may actually cost less and be more streamlined with better results, because they're going to actually consider all of your loved one's needs. They're not going to just take a urine sample upon their entry and let them go in an hour. And then you're up to know, right? How will that 1 hour go? I don't know how that 1 hour will go. I think that observing a patient over a 72-hour period and having multiple experts do assessments on them is certainly going to get a better result or outcome for the truth, right? What is actually going on with this patient? So it lasts potentially 72 hours. Um, it could go a little bit longer, and some facilities have the authority to release them.
Sure, it's the resistance. When this is a long process for somebody who's going through this assessment, I know I would feel that was a long process. What if those folks become resistant or non cooperative?
Yeah, obviously there are going to be people who might resist. I think most families think that if they're going to the Marchment Act, their loved one's always the one in the resisting category. Um, and that's not usually true. The majority of our patients are I should say, the majority of our clients, right, who work with us to petition for their loved one, who is the patient, right? Um they're getting an order from the court that indicates the facility can keep them for that 72-hour period. And they're getting law enforcement to pick them up, who's bringing them to the facility, who's indicating that they must follow this order. And so there will be people who resist, but it's a much smaller group of people than most families think. Out of the people who do resist, whether they run away in non-compliance with the court order or they stay for a certain period of time and then they say, I'm done and enough is enough and I'm leaving and I'm not going to follow through. The facility should have the ability to explain to them, hey, this court determination includes what your history of lack of compliance with treatment is. And so being resistant and not complying with the assessment is certainly going to play into our assessment recommendation of whether or not you've been non-compliant with treatment in the past. We will certainly be required to let the court know that you've been resistant, and that can decrease your chances of success as a patient in fighting the potential order at your hearing. So you should stay, right? But even that noticeable resistance needing to be redirected is an indication that the individual lacks their understanding of need for care if that's the recommended level of care. If they do in fact leave, there are ways to address that. Sometimes you just go forward to the treatment hearing. You have the hearing date, they've already been served, they already know about it, the family's aware, the individual leaves the facility, the hearing's in 2 days' time. You might just go to the hearing and say, Your Honor, we have our assessment, it was already done. Other times, the facility doesn't have the opportunity to really perform the assessment, and there are legal mechanisms which can be filed that may be recommended in particular cases, which can hold the individual in contempt of court for refusing to abide by the court's order. If they leave treatment before the assessment's completed and the facility notifies the court as such, or the family notifies us and we file something as such, the combination of those two, the family is saying this individual didn't get their assessment under the court order. The facility is saying, yeah, we had the patient and they resisted and refused. Then it becomes they're in non-compliance with the court's order, not just treatment. And so there's potential indirect contempt considerations that the patient would be subjected to.
And then, Richard, at the end of the assessment period, what legal decisions can the court make based on their findings?
So the court has the ability to kind of hear all of the testimony and evidence. So from family members and their prior history for treatment, from treatment providers that have done the assessments, and from the respondent, which is what the patient's legal name is in the case. So the patient in their case, they're allowed to put on evidence about what it is that they believe is a more accurate side of the story, right? Just like any other proceeding, and the court makes the determination of the findings of, do the facts support the requirements of the Marchment Act? Is the individual substance abuse impaired, right? Do they have a diagnosed substance use disorder or not? Did the individual have a history of lack of compliance with treatment for substance abuse? Um, is that the case or not? Um, and then there are other requirements. Is the individual likely to voluntarily participate in treatment as recommended, or they need to be there involuntarily? And then, can they appreciate their need for care? Are they a danger to themselves if they're not in treatment? Right. So looking at these things, and there are some that are and there are some that are or. And the court says, I find that this individual meets the criteria. The evidence here supports a recommendation for a certain level of care. There is an available treatment facility that's available and appropriate that's been brought in as evidence that there was an available and appropriate treatment center presented by the petitioner, the respondent, and the petitioner agree, whatever it may be, that is available and appropriate. And so the individual needs to be in treatment for a period up to 90 days at a designated facility, starting at the level of care that facility thinks is appropriate, starting at the level of care that uh, uh, the the expert who's at the hearing testified was appropriate. Um, and they must continue to follow the rules and recommendations of that facility over that period of time, up to a maximum of 90 days. Um, the court doesn't make any future determinations. The law allows you to petition towards the end of the 90 days to have a renewal of a new 90-day period, but the court doesn't make any determinations as that at the first hearing. They would only make those determinations if those filings are made. They could require you to come in for status checks, just like any court could. They could say, I want to see this patient in another 30 to 45 days. Everybody come in and let's see how things are progressing. So they really determining, do they meet the criteria? Yes or no? If they meet the criteria, what level of care and what named treatment program should they be in? And for a period, which should be up to 90 days in length based upon the way the law is written.
Thank you so much for your guidance through this. It's a complicated process, but you've made it sound manageable, and I know how you guide your clients through it. So thank you for sharing that today.
Thank you, Lisa. I appreciate it.
You're welcome, folks. That's it for today's episode of A Way Forward, The Right to Recover. If you'd like to learn more about Richard Casey and the work at Robinson Casey PLLC, including resources related to the Marchment Act in Florida, visit robinsoncasey.com. Thanks for listening, and don't forget to subscribe, leave a review, and share this episode with someone who may be trying to help a loved one through this difficult situation. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.